So getting your guns back. Petitioning the court after a dangerousness finding. So the court kept your guns. You lost your final retention hearing. The court found that you were dangerous. What do? How do you get your guns back? Well, your guns are going to be taken and they're going to be retained temporarily. But what do you need to do to get them back? Is there a way to get them back later? Yes, there is. And that's by filing a petition to show you're no longer a risk. So first, what does that process look like? Well, first, you are now going to file a petition with the court that issued the retention order. So you're going to file a petition. You're going to say, Judge, I believe I'm no longer a risk. I believe I'm no longer dangerous. I would like my firearms back. You file that with the court. So how quickly can you do this? Well, it's not something you get to file the day after the court orders that your guns are going to be retained. There is a waiting period. There's a timeline. You have to wait at least 180 days since the retention order was issued. So effectively 6 months since the court order your guns would be retained, you can then file a petition to address that. And here is important because during all the initial things, during the first hearing, during the final retention hearing, the state had the burden. They had the burden to first show probable cause, and then they had the burden to show clear and convincing evidence. But now that you're the one filing the petition, now the one that you're initiating this, you now have the burden. The burden is shifted. So you must prove by a preponderance of the evidence that you're no longer dangerous. Now that's another legal standard here. We've talked about clear and convincing. We've talked about probable cause. This is preponderance of the evidence. Preponderance of the evidence is more likely than not. So it's actually a much lower legal standard than clear and convincing evidence. So you effectively have to show that it's more likely than not that you are no longer dangerous. So this makes it easier to argue than clear and convincing. That would be a much higher standard for you to have to argue. So you have a right to have a hearing on this. You file the petition, you have a right to have a hearing. At that hearing, you're going to have the opportunity to present evidence and arguments. And again, you can be represented by an attorney at this hearing. And that evidence can be in the past 6 months. Maybe your guns were taken because you had mental health issue, which could have been treated, but you didn't have the medication. And you can say, hey, I've had the medication for the last 6 months. I take it every day. I'm doing great. Here's my doctor. Here's friends that can say that. There's other reasons. Maybe a year ago, you made some threats, and so your guns were taken, but you've been doing really great since. This is all evidence that you can present. And so then based on that evidence, the judge is going to determine if you've met that preponderance standard, if it's more likely than not that you're no longer dangerous. So what are the outcomes? Well, the state could win, right? The judge could say, no, I don't think you've met your burden. I think you are still dangerous. If that's the case, the order just remains in effect, right? Your guns are still going to be retained. But if you win, then the court finds that it's more likely than not that you are no longer dangerous, then the court is going to reinstate your ability to possess and carry firearms, and any licenses that you had are likely going to no longer be suspended. If you have any questions about what you need to do to file a petition to get your guns back after they've been taken, don't hesitate to call us here at the Marc Lopez Law Firm. Our number is 317-632-3642. And remember, always plead the fifth.